The nays are 0. The Senate will now proceed. To legislative business. The chair will now move to calendar number 2, Senate Resolution 18, to hold Zulus Centurion in contempt of Congress for its first reading. So Senate Resolution 18 to hold Zulus Centurion in contempt of Congress. Whereas Zulus Centurion on multiple occasions refused to answer questions posed by the Congress under subpoena in violation of 2 U.S. Code 192, resolved, Zulus Centurion shall be found in contempt of Congress for failure to comply with a congressional subpoena. Resolved, the President of the Senate shall otherwise take all appropriate action to enforce the subpoena. This item is referred to the Committee on Rules and Administration. The chair will now move to calendar number 3, Senate Resolution 5, disapproving the action of the District of Columbia Council in enacting the Criminal Sanity Preservation Act. A joint resolution resolved by the Senate and the House of Representatives of the United States of America and Congress assembled that the Congress disapproves of the action of the District of Columbia Council described as follows. Criminal Sanity Preservation Act, Ordinance 25-6. The Congress, acting as the legislature of the District of Columbia under Article 1, Section 8, Clause 17, hereby designates that such action made by the Council shall have no further force or effect. The chair will now move to calendar number 4, Senate Resolution 17. Oh, wait, no. Whoops. The previous item, Senate Resolution 5, is referred to the Committee on the Judiciary. The chair will now move to calendar number 4, Senate Resolution 17, to amend the standing rules. Senate Resolution 17. No resolution, rule, or order heretofore adopted by Congress or its bodies adopted prior to the passage of this resolution may supersede or take precedence over the provisions herein. Ambiguous or uncertainty regarding any of the provisions in this resolution may be interpreted and adjudicated by the Federal Election Commission, and their decision shall be binding unless overturned by the Senate. Elections for eligible vacant offices of the congressional leadership at the adoption of this resolution shall be held following the adoption of this resolution by the President pro tempore. Section 2. Whereas as prescribed in Senate Joint Resolution 10, the authorized public forum voting venue for all business concerning the elections of Senate officials, unless amended, shall be recognized as a congressional discord. At the completion of all elections via Senate public forum, the Secretary of the Senate, or in his absence, the presiding officer of the Senate, shall certify the results and transmit the results to the appropriate congressional body within its main communication channel. Such transmission shall be made to be delivered with a list of all the votes of the elections. Following the certification of election within the Senate, the results of the election shall be made available for the public eye by the Secretary of the Senate, who shall ensure the publication and dissemination of the election tally. Details of the release shall indicate the cast of votes indicated or attributed to each candidate by members of Congress. Upon the release of the certification by the Secretary of the Senate, the election shall be entered into records of Congress and deemed final. No further objections or challenges to the outcome of the election may be entertained by Congress. During legislative business, the Senate may cast a vote for any pending election and shall not necessitate the convening of Congress. Such vote shall be permitted in the recess of Congress. Rule 1, Clause 1 shall be amended to read as follows. In the absence of the Vice President, the Senate shall choose, through public form vote, a President pro tempore, who shall hold the office and execute the duties thereof during the pleasure of the Senate, and until another is elected or their term of office as a senator expires. Rule 27, Clause 2, Subclause A, shall be amended to read as follows. The Senate may nominate an individual who is not a member of Congress to Secretary of the Senate, who shall serve at the pleasure of the Senate. The Secretary shall perform the duties herein stated in the standing rules of the Senate, and shall only be removed by the same proceedings of the elections through public forum. The Secretary may be suspended, and a temporary one shall be appointed by the President pro tempore. Such suspension shall last no longer than 1 week, in which the PPT shall present a motion to the Senate at session to remove the Secretary. If such motion does not occur or fails, then the suspension shall be lifted. Rule 20, Clause 4, Subclause A shall be amended to read as follows. The Majority Leader will be elected by public forum by the members of the party with the most members, who shall hold the office and execute the duties until another is elected or his term of office as a senator expires. Rule 9, Clause 3 shall be amended to read as follows. Voting shall not last less than 1 minute during an active session, and in business concerning the public forum as venue shall not last less than 48 hours. Rule 27, Clause 4, Subclause B shall be amended to read as follows. The Minority Leader will be elected by public forum by the members of the party with the second most members, who shall hold the office and execute the duties until another is elected or his term of office as a senator expires. Rule 21, Clause 1, Subclause B 1.1 shall be amended to omit the paragraph, "This does not extend to buildings in the main Washington, D.C. game," in the following. Administration of the Senate chambers, including the assignment of office space. Crossed out, "This does not extend to buildings in the main Washington, D.C. game." Rule 3, Clause Oaths. First rule shall be amended to omit the paragraph "in open Senate" in the following. The oaths or affirmations required by the Constitution and prescribed by law shall be taken and subscribed by each senator, crossed out, in open Senate before entering upon his duties. This item is referred to the Committee on Rules and Administration. The chair will now move to calendar number 5, Senate Resolution 44, Group Management Communication Act 2024.
In the reading, please continue.
Yes, Senator Hellenick, it is continuing.
Thank you.
Title 1, okay, Group Management Communications Act 2024, Title 1, General Provisions. This act is severable such that if any section, subsection, sentence, clause, phrase, word, provision, or application becomes illegal, unenforceable, or invalid in any jurisdiction, it shall not affect the enforceability or validity in that jurisdiction of any other provision of this act. Section 102. This act has a short title, Group Management Communication Act of 2024. Section 103. This act shall take immediate effect. Title 2, Interaction with the Group Management. Section 201. The Congress of the United States finds that the current system of negotiation and communication with the group management leads to communications and agreements not representing the opinion of the government, nor does it respect the legislative authority of the Congress. Section 202. There shall be the Group Management Communications Commission as an instrumentality of the United States to conduct all communications on behalf of the United States. The Group Management Communications Commission shall be composed of the President of the United States, the Vice President of the United States, the Speaker of the House of Representatives, the President pro tempore of the Senate, and a representative of the judiciary selected by Supreme Court. Section 203. The Group Management Communications Commission shall collectively receive and transmit communications between the group management and the United States. The Group Management Communications Commission shall select a representative of the United States to the Military Board of Governors who shall operate under the direction and authority of the Commission. The Group Management Communications Commission shall conduct all negotiations, resolve all disputes, and shall have the sole authority, other than an act of Congress, to come to binding agreements with group management. Section 203. No person holding an office derived from the Constitution or laws of the United States shall make communications requesting an action of the group management that expands, restricts, or otherwise alters the organization, authorities, responsibilities, or relationship with the United States of any officer, employee, office, agency, court, chamber of Congress, or any other instrumentality or subordinate entity of the United States. Subsection A shall not be construed to the effect that such person may not make communications that require an action of the group management that is related to moderation, administrative powers within government discords, or the clerical duties entrusted to the National Records and Archives Administration. Any person holding an office derived from the Constitution or laws of the United States may transmit to the Group Management Communications Commission a request that such commission transmit to the group management a request of a nature described in subsection A, which shall be transmitted upon a majority vote of the Group Management Communications Commission. Any person who violates or attempts or conspires to violate subsection A shall be sentenced to a term of imprisonment for 3 months and shall be incapable of holding any office under the United States. This item is referred to the Committee on the Judiciary. The chair will now move to calendar number 6, Senate Resolution 47, New Civil Offices Act of 2024. One second. Senate Resolution 47, New Civil Offices Act of 2024. Whereas the Constitution has changed the definition of civil offices in Clause 2 of the 12th Amendment, this bill shall amend civil office requirements created by old law to follow the new constitutional requirements. Title 1. Section 101, this act shall be referred to as the New Civil Offices Act of 2024 as a short title. Section 102, this act remains severable in accordance with severability doctrine maintained and developed by the courts of the United States. This act shall come immediately come into effect upon passage. Title 2, Fixing Civil Offices, Section 201. Section 201, AI 1 to 3 of the Civil Offices Act of 2024 shall be striked. Section 201, subsection A, subsection I, subsection 1 shall instead read, appointed members of the National Employment and Labor Authority shall not require the advice and consent of the Senate. Section 201, subsection A, subsection I, subsection 2 shall instead read, appointed members of the tribunals of statutory compatibility shall not require the advice and consent of the Senate. Section 201, subsection A, subsection I, subsection 3 shall instead read, any other act which explicitly states that such an office is not defined as a civil office does not require the advice and consent of the Senate. Section 105, subsection B of the National Employment and Labor Act of 2024 shall be striked and shall instead read, all members of the NELA shall be appointed by the President. 28 U.S. Code 505 shall be striked and shall read, the President shall appoint in the Department of Justice a Solicitor General learned in the law to assist the Attorney General in the performance of his duties. This item is referred to the Committee on the Judiciary. Okay. Pursuant to Rule 1 of the Senate Standing Rules, I appoint Asaraf to the chair for the reading of calendar number 7, Senate Resolution 42, Federal Commerce and Labor Act.
A bill to formally establish and define the United States Department of Commerce and Labor. Be it enacted by the Senate and House of Representatives of the United States and Congress assembled. Section 1, short title. This bill shall be referred to by its short title, Federal Commerce and Labor Act, or FCLA. Section 2, severability. This act shall be severable such that if any word, phrase, line, sentence, or provision of this act, or the application of any of them to any person or circumstance is held invalid, their application to other persons or circumstances, and the remainder of this act shall not be affected thereby. This act shall not be superseded by any newer law unless that law specifically declares its intent to supersede this act's provisions. Section 3, effectiveness. The bill shall be effective immediately upon passage by both chambers of the Congress and signature of the President of the United States or its otherwise becoming law, unless an article of this bill shall otherwise explicitly mention an alternative effective date or duration, in which case that article shall become effective at the specified date. Section 1, general provisions and definitions. Section 101, definitions. The term department is defined as the Department of Commerce and Labor. The term secretary is defined as Secretary of Commerce and Labor. The term revoked or revoked is defined as temporary removal of anything issued by the department from the possession of the individual or entity to whom it was issued. D. The term blacklisted or blacklist is defined as the prohibition of a person or entity from requesting or possessing anything issued by the department. E. The term disperse is defined as refers to the act of broadcasting, publishing, or distributing. F. The term manage refers to authority to revoke, suspend, or blacklist. G. The term applicant refers to any individuals applying for a business license in the Department of Commerce and Labor. H. The term stipend refers to the payment or remuneration given to someone for some service. Title II, the Department. Section 102, creation of the Department of Commerce and Labor. A, there shall be in the United States executive branch an executive department to be known as the Department of Commerce and Labor, and a Secretary of Commerce and Labor who shall be the head thereof, who shall be appointed by the President with the advice and consent of the Senate, and whose term and tenure of office shall be like that of the heads of the office of the other executive departments. B, there shall be in said department a Deputy Secretary of Commerce and Labor to be appointed by the President with the advice and consent of the Senate. He shall perform such duties as shall be prescribed by the Secretary or prescribed by law. Section 103, Leadership Establishment. There shall be in the Department of Commerce and Labor a bureau to be called the Bureau of Commerce, and an undersecretary who shall be the head of that bureau to be appointed by the Secretary of Commerce and Labor, and who shall also perform such other duties as may be assigned to him by the Secretary of Commerce and Labor. The Bureau of Commerce and Labor shall be responsible for overseeing the following offices. I, there shall be in the Bureau of Commerce and Labor of the Department of Commerce and Labor an office to be called the Office of Business Licensing, and an Assistant Secretary of Business Licensing who shall be the head of that office, appointed by the Secretary of Commerce and Labor. There shall also be in said Bureau a Supervisor of Business Licensing who shall, in the absence of the Assistant Secretary, act as and perform the duties of the Assistant Secretary of Business Licensing, and who shall also perform such other duties as may be assigned to him by the Secretary of Commerce and Labor. The duties of the Office of Business Licensing shall extend to the certification, to manage and to disperse the applications and received for business registration through an accessible registration form or request in the official Department of Commerce and Labor Discord server, and shall perform such other duties as the Secretary shall prescribe or as required by law. B, there shall be in the Department of Commerce and Labor a bureau to be called the Bureau of Labor, and an Undersecretary of Labor who shall be the head of that bureau to be appointed by the Secretary of Commerce and Labor, and who shall also perform such other duties as may be assigned to him by the Secretary of Commerce and Labor. The Bureau of Labor shall be responsible for overseeing Bureau of Labor shall be responsible for overseeing the following offices. That shall be in the Bureau of Labor of the Department of Commerce and Labor in Memphis to be called the Office of Business Investigations, and an Assistant Secretary of Investigations who shall be the head of that office, appointed by the Secretary of Commerce and Labor. And there shall also be in said Bureau a Supervisor of Investigations who shall, in the absence of the Assistant Secretary, act as and performs the duties of the Assistant Secretary of Investigations, and who shall also perform such other duties as may be assigned to him by the Secretary of Commerce and Labor. The duties of the Office of Business Investigations shall extend to the investigations of income reports made by a report form maintained by the leadership of the Department of Commerce and Labor that involves the contravening of business regulations set forth by the Department of Commerce and Labor outlined in Section 103D. Shall also perform such duties as the Secretary may prescribe or as required by law. Office of Business Investigations employees shall take the following oath upon employed by the office. I do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter, so help me God. 2, there shall be in the Bureau of Labor of the Department of Commerce and Labor a sub-bureau to be called the Bureau of Labor Statistics, and an Assistant Secretary of Statistics who shall be the head of that office, appointed by the Secretary of Commerce and Labor. There shall also be in said bureau a Supervisor of Statistics who shall, in the absence of the Assistant Secretary, act and perform the duties of the Assistant Secretary of Statistics, and who shall also perform such other duties as may be assigned to him by the Secretary of Commerce and Labor. The duties of the Bureau of Labor Statistics shall extend to collecting, analyzing, and publishing data on many aspects, including but not limited to A, employment and unemployment in the United States, as well as aspects such as job openings, hires, separations, and labor force participation. B, forecasts of job growth or decline in different occupations and industries over the next decade. C, information on stipends given to employees based on their job performance. C. There shall be in the Department of Commerce and Labor an office to be called the Office of the Inspector General, and an Inspector General who shall be the head of that bureau to be appointed by the President with the advice and consent of the Senate. There shall also be inside the office a Deputy Inspector General who shall, in the absence of the Inspector General, act as and perform the duties of the Inspector General, and who shall also perform such other duties that may be assigned to him by the Secretary of Commerce and Labor. The Office of the Inspector General shall operate with the same responsibilities, jurisdiction, and powers as outlined in 5 U.S. Code, Chapter 4. Section 104, Structure and Jurisdiction. The United States Department of Labor, 29 U.S. Code, Chapter 12, and the United States Department of Commerce, 15 U.S. Code, Chapter 40. Assets, personnel, liabilities, and responsibilities are transferred to the Department of Commerce and Labor. B. The Small Business Administration, 15 U.S. Code, Section 633, the Office of the U.S. Trade Representative, 19 U.S. Code, Section 2171, and the Federal Trade Commission, 15 U.S. Code, Subchapter 1, Assets, personnel, liability, and responsibilities are transferred to the Department of Commerce and Labor. C. The Department of Commerce and Labor shall inherit all authorities and obligations of their respective incorporated entities, including agencies, departments, offices, bureaus, commissions, or other government bodies, along with the roles, powers, and responsibilities outlined in Title 15, Chapter 2, 2A, 2B, 2B1, 2C, 2D, 2E, 3, 5, 14A, 14B, 22, 27, 34, 40, 45, 45A, 46A, 48, 66, 73, 74, 84, 87A, 88, 93, 97, 98, 99, 101, 120, and Title 29. Jeez. B or D. Department of Commerce and Labor shall have the authority to issue, oversee, and manage the licenses of businesses and their owners as the Secretary finds appropriate. 2. Administer, control, and allocate licenses for media organizations, law firms, and other general enterprises. 3. Supervise, regulate, and distribute permits for events and special significance. 4. Administer and control the licensing of labor unions or other labor-related organizations. 5. Manage, oversee, and regulate licenses for sole proprietorship, partnerships, general limited liability companies, and non-stock corporations with full authority to establish the legal standards and requirements for their operational documents at a department's discretion. 6. Examine and investigate any claims or reports of misconduct involving businesses, which encompasses but is not limited to their communications, records, and employee files. 7. Conduct thorough investigations of a business's licensing status every 60 days, which includes reviewing their communications, records, and employee files. B. The Secretary of Commerce and Labor shall be responsible to maintaining a public and accessible document outlining the regulations and policies on the usage of business licenses and operations of businesses in the United States. 1. The Secretary of Commerce and Labor, upon modifying the designated regulations and policy documents as prescribed in Section 103D, shall be required to notify operational business owners or a delegate of any changes. This notification shall occur through the Department of Commerce and Labor official Discord server, giving a 72-hour notice before adverse action may occur against business for contravening regulations and policies. The Secretary of Commerce and Labor shall have the authority to temporarily blacklist an individual, a group of individuals, the ability to obtain a business license on the following grounds. The applicant's previous business has been involved in criminal activities. The applicant's previous business has been operating without a business license granted by the Department of Labor. The applicant has been designated a national security threat. This temporary prohibition cannot exceed 60 days from the date of issuance. E. The Secretary of Commerce and Labor shall have a public database accessible by the public containing available records. Having a public database accessible by the public containing available records of registered businesses with the Department of Commerce and Labor. Said database shall include, but is not limited to, the following information: 1. Name of business. 2. Business owners. 3. Business Discord server permanent invite. 4. Business Roblox group, if applicable. 5. Business type. 6. Date issued. 7. Roblox and Discord username of the authorizing employee. F. That a Secretary of Commerce and Labor may refuse to license a business for the following reasons. 1. Incomplete or incorrect information provided by the business. 2. Operation of business without registration. 3. Failure to adhere to any posting guidelines produced by the Department of Commerce and Labor or established by law. 4. Has had a business closed by the Secretary of Commerce and Labor or by court order in the last 30 days. G. The Secretary of Commerce and Labor shall have the authority to revoke a business license for the reasons in Section 103H. H. If a business owner feels that the suspension or rejection of their business did not adhere to the conditions in Section 103H, they may file a civil lawsuit against the Department of Commerce and Labor to the district court, where a judge may determine if the license revocation did not satisfy the conditions in Section 103H. If a judge rules in favor of the business, the secretary shall be required to reinstate the business license. Section 105, business registration. A. To operate lawfully within the United States, a business domestically or foreign-based must register with the Department of Commerce and Labor. B. The secretary shall create an easily accessible online form to be known as Form 1A, Articles of Incorporation, which shall require the following: 1. Business name. 2. Discord permanent server invite link. 3. Owners of the business. 4. Business type. 5. Place of operations. C. Businesses seeking to operate within the United States shall submit to the Department of Commerce and Labor a completed Form 1A. The Secretary of Commerce and Labor, upon receiving the completed form, shall record and archive its information and register the business. 1. Registration shall not be conditioned on the signing or agreement to any contract or compact by registering party. 2. The Secretary of Commerce and Labor shall be authorized to amend the structure and contents of Form 1A as the Department of Commerce and Labor deems it necessary and appropriate. Section 106, Job Fair Program. Once or twice a month, the Department of Commerce and Labor shall host a job fair where registered businesses and governmental entities shall be authorized to offer employment opportunities to individuals holding American citizenship. 1. Businesses and governmental entities shall register with the Department of Commerce and Labor to participate in the job fair program. 2. Businesses and governmental entities participating in job fairs shall submit to the Department of Commerce and Labor data regarding the number of new employees hired from the fair. Section 107. A. The following shall be authorized and available business types to register the Department of Commerce and Labor. 1. Financial institutions. 2. Food, law firm, and logistics. 4. Media and entertainment. 5. Retail. 6. Security. 7. Housing. 8. Technology. 9. Transportation. 10. Miscellaneous. 11. Corporations. Section 108. Regulation of licenses. A. Operating businesses without a valid license shall be considered unlawful, and the owner shall be subject to a penalty of up to $10,000 or a maximum of 4 days in federal incarceration. Section 109. Requirements to operate a business. In order to operate a business in the United States, an applicant must be a citizen of the United States for at least 1 month, have at least 3 employees in the business they are applying a license for, where the business owner does not count towards the required employee count, and 3. Have a Discord server dedicated solely to the business operations. Section 110. Business renewals and expirations. A. Business license shall last 3 months from the date of issuance. B. Business license revocations shall have a 72-hour grace period where business owners have the chance to appeal revocation. The Office of Business Licensing is required to notify business owners immediately that their business license is being revoked, signifying the beginning of the 72-hour grace period. D. After the 72-hour grace period has finished and the business owners has not contacted the Department of Commerce and Labor Office of Business Licensing to appeal, or that their appeal was insufficient and did not satisfy the department's regulations for renewal and activity, then the Office of Business Licensing reserves the right to revoke the license without further notice. E. In order to be eligible for a business license renewal, business owners are required to be inspected once during 3 months of their license duration. Such inspections are done by the Department's Office of Business Investigations. Such reports shall include the following: a checkmark list of the Department of Commerce and Labor's regulations. Through the inspection and designated inspector is tasked with ensuring that the business being inspected is following regulations set forth by the department and by law. 2. Outcome of the inspection. F. If a business fails the inspection process due to the contravening of business regulations or the law, that business license shall be considered revoked, and a certified copy of the Assistant Secretary of Investigations of the inspection report shall be delivered to the Secretary of Commerce and Labor for final approval and official revocation of the business license. G. If a designated inspector fails to correctly grade a business inspection report, internal action shall be made by the Office of Business Investigations, and the report shall be considered nullified. In that case, another inspector is designated by the Assistant Secretary of Investigations. Section 111, Amendment of U.S. Code. 5 U.S. Code Section 101 shall be amended to read as the executive departments are the Department of State, Department of Treasury, Department of Defense, Department of Justice, Department of Commerce and Labor, Department of Housing and Urban Development, Department of Transportation, and the Department of Homeland Security. Section 112, Amendment of S37. S37, Title 2, Section 201, AI shall be amended to add 5, the Inspector General of the Department of Commerce and Labor. Title 2, the Business Regulations and Guidelines. Section 1, Business Regulations. A, upon the passage of this bill, the Department of Commerce and Labor shall implement and use the following business guidelines and regulations. Chapter 1, Universal Guidelines. Department of Commerce and Labor shall maintain publicly accessible records of business registered with the department. B, every entity that registers with the Department of Commerce and Labor as a business agrees to adhere to the business guidelines and regulations maintained by the department. C, businesses are required to employ at least 2/3 American citizens ranked within the USA, the United States of America Roblox group. D, registered businesses with the department shall maintain a high standard of activity for the duration of their business license. The Small Business Administration shall be responsible for aiding businesses struggling to maintain activity. Businesses not maintaining the activity standard required by the department shall be subject to license revocation. E, registered businesses must have an accessible public discourse server in order to be eligible for license registration with the department. The applicant business owner shall provide to the department a permanent invite to the Discord server used for business purposes. Such communication servers must be solely for business operations. F, registering an existing business shall be prohibited. New iterations of the business that have been terminated from the department's registry are permitted and, in many cases, encouraged. G, the department shall not permit businesses to engage in illegal activities and shall refuse to license businesses whose practices are illegal or unethical. Chapter 2, Business Categories. A, the following categories shall be the authorized categories for the department's licensing options. 1, financial institutions. 2, food. 3, law firm and logistics. 4, media and entertainment. 5, retail. 6, security. 7, housing. 8, technology. 9, transportation. 10, miscellaneous. 11, corporations. If that sounds familiar, it is a repeat of something else in this bill. Department of Commerce and Labor shall not, under any circumstances, register a criminal organization. Chapter 3, Roblox Groups Policy. Businesses listed below are required to own a Roblox group in order to be registered by the department. As such, their employees will be counted within the same group in accordance with Section C of the first chapter of the regulations. Roblox groups shall be inspected upon and must meet a standard which will be left to the decision of the individual inspecting / registering. Financial institutions, food, retail, security, housing, transportation. Businesses categories that appear in the list provided in Chapter 2 but not in the list above are still required to have a Discord communication server to be registered. Chapter 4, Corporations. Corporations that wish to register with the Department of Commerce and Labor must own at least 2 licensed businesses in order to be recognized. Corporations cannot own other corporations. Exception can be made by the Secretary of Commerce and Labor. Policy enforcement. During and upon registration, business owners and employees agree to follow the business guidelines and regulations of the Department of Commerce and Labor. Chapter IX, Business License Renewals. Business license shall last 3 months from the date of issuance. B, business license revocation shall have a 72-hour grace period where business owners have the chance to appeal revocation. The Office of Business Licensing is required to notify businesses owners immediately that their business license is being revoked, signifying the beginning of the 72-hour grace period. If a business fails the inspection process due to the contravening of business regulations or the law, that business license shall be considered revoked, and a certified copy of the Assistant Secretary of Investigations of the inspection report shall be delivered to the Secretary of Commerce and Labor for final approval and official revocation of the business license. If a designated inspector fails to correctly grade a business inspection report, internal action shall be made by the Office of Business Investigations, and the report shall be considered nullified. In that case, another inspector is designated by the Assistant Secretary of Investigations. Chapter 10, Business Guidelines and Regulation Amendments. A, the Secretary of Commerce and Labor shall be authorized to amend, modify, and update the business guidelines and regulations as deemed necessary. Provided, however, that such amendment, modifications, or updates shall not alter, affect, or otherwise impair any provisions or stipulations set forth within this Act. B, Secretary of Commerce and Labor shall be required to notify business owners or a delegate of any changes to the business guidelines and regulations. Such notification shall President.
Yes, Senate Majority Leader asks reps.
All you. You can take over again. It's done.
Okay. Chair shall resume reading of legislative business. All senators will bear with. Senate Majority Leader Assaraps, did you finish reading Senate Resolution 42, Federal Commerce and Labor Act? Okay. Okay. The chair will now move to calendar number 8, Senate Resolution 43, Military Traders Act of 2024.
You need to refer the other one to a committee.
Right.
It failed the committee.
It was never referred.
It was.
Senate Resolution 42 is referred to the Committee on the Judiciary. The chair will now move to calendar number 8, Senate Resolution 43, Military Traders Act of 2024. Military Traders Act of 2024. To sanction and restrict the activities of officials interacting with the Military Board of Governors. Title 1. Section 101. This act is severable such that if any section, subsection, sentence, clause, phrase, word, provision, or application becomes illegal, unenforceable, or invalid in any jurisdiction, it shall not affect the enforceability or validity in that jurisdiction of any other provision of this act. Section 102. This act has a short title, Military Traders Act 2024. Section 103. This act shall take immediate effect. Title 2. Interaction with the Military Board of Governors. Section 201. The Coast Guard is removed from the authority of the Department of Homeland Security until such time it is removed from the purview of the Military Board of Governors. The Coast Guard shall perform no activities within the borders of the United States until such time it is removed from the purview of the Military Board of Governors. Section 202. Any official requiring the advice and consent of the Senate of the United States or constituting an officer or inferior officer of the United States may not appear before or vote on any item before the Military Board of Governors, nor shall a proxy or subordinate official or employee on their behalf. Any person who violates or attempts to conspire to violate subsection A shall be sentenced to a term of imprisonment for life and shall be incapable of holding any office under the United States. Title 3, Independent Counsel for Military Insurrection. Section 301. The United States District Court shall appoint an appropriate independent counsel under this title. The District Court shall appoint as independent counsel an individual who has appropriate experience and who will conduct an investigation and any prosecution in a prompt, responsible, and time-effective manner. The District Court shall seek to appoint as independent counsel an individual who will serve to the extent necessary to complete any prosecutions under this act. The division of the court may not appoint as an independent counsel any person who holds any office or profit or trust under the United States. The scope of the independent counsel's prosecution shall be restricted crimes under Section 202 of this act and crimes under Title 18, Part 1, Chapter 15 of the United States Code in connection to any member, employee, or officer of the Department of Defense, Department of Homeland Security, and the Armed Services of the United States. If a vacancy in offices arises by reason of the resignation, death, or removal of the independent counsel, the division of the court shall appoint an independent counsel in the same manner as subsection A. Section 302, notwithstanding any other provision of law, an independent counsel appointed under this chapter shall have, with respect to all matters in such independent counsel's prosecutorial jurisdiction established under this chapter, full power and independent authority to exercise all investigative and prosecutorial functions and powers of the Department of Justice, the Attorney General, and any other officer or employee of the Department of Justice. Such investigative and prosecutorial functions and powers shall include conducting proceedings before grand juries and other investigations, participating in court proceedings and engaging in any litigation, including civil and criminal matters that such independent counsel considers necessary, appealing any decision of a court in any case or proceeding in which such independent counsel participates in an official capacity, reviewing all documentary evidence available from any source, determining whether to contest the assertion of any testimonial privilege, receiving appropriate national security clearances, and if necessary, contesting in court, including where appropriate, participating in camera proceedings, any claim of privilege or attempt to withhold evidence on grounds of national security, making advice to any federal court for grant of immunity to any witness, consistent with applicable statutory requirements, or for warrants, subpoenas, or other court orders, and for purposes of Section 6003, 6004, 6005 of Title 18, exercising the authority vested in a U.S. Attorney or the Attorney General, initiating and conducting prosecutions in any court of competent jurisdiction, framing and signing indictments, filing information, and handling all aspects of any case in the name of the United States, and consulting with the U.S. Attorney for the district in which any violation of law with respect to which the independent counsel is appointed was alleged to have occurred. Each independent counsel appointed under this chapter are separate from and independent of the Department of Justice. This item is referred to the Committee on Homeland Security. The chair will now move to calendar number 9, Senate Resolution 5, Department of Justice Reorganization Act of 2024. Pursuant to Rule 1, I appoint Snowbleed to the chair for the reading of calendar number 9, Senate Resolution 5, Department of Justice Reorganization Act 2024.
Thank you so much. A bill, short title, this piece of legislation shall be referred to as the Department of Justice Reorganization Act of 2024, Section 2, General Provisions. Any part of any act, joint resolution, memorandum, or codified law that conflicts with this act shall be deemed null and void. This act shall be servable, in which, if any provision of this act is found unconstitutional, the rest of the act shall be in full effect, unless also found unconstitutional. This act shall go into effect immediately. Section 3, Restructuring of Assistant Attorney Generals. In general, Chapter 31 of Title 28 United States Code is amended as follows. I. Section 506 of Title 28 United States Code is amended by 1. Striking 11 Assistant Attorney Generals and inserting 5 Assistant Attorney Generals. 2. Striking the President shall appoint by and with the advice and consent of the Senate, and inserting the Attorney General shall appoint. 3. Inserting after Section 506 the following new section. A. 506A paragraph. Criminal Division. I. Appointment of the Assistant Attorney General appointed under Section 506. One shall serve upon the designation of the Attorney General as Assistant Attorney General for the Criminal Division. B. Duties. The Assistant Attorney General for the Criminal Division shall 1. Head the Criminal Division of the Department of Justice, 2. Oversee all federal criminal prosecutions except those explicitly delegated to the National Security Division, 3. Supervise the enforcement of all federal criminal laws except for those specifically assigned to other divisions, 4. Coordinate with United States attorneys in the conduct of criminal prosecutions, 5. Develop and implement criminal law enforcement policies and strategies, 6. Provide guidance and support to federal, state, and local law enforcement agencies in criminal matters. B. Criminal Division. The Criminal Division shall be composed of attorneys at law responsible for all matters assigned to the Assistant Attorney General for the Criminal Division and shall operate under the Assistant Attorney General's direction, organization, and supervision. 4. Inserting after Section 506A the following new section. A. Paragraph 506B, Civil Division. I. Appointment of the Assistant Attorneys Generals appointed under Section 506. One shall serve upon the designation of the Attorney General as Assistant Attorney General for the Civil Division. 2. Duties of the Assistant Attorney General for the Civil Division shall 1. Head the Division of the Department of Justice, 2. Represent the United States and agencies, members of Congress, cabinet officers, and other federal employees in any civil or criminal matter within the Civil Division's scope of responsibility and discretion, which may be set by the Attorney General. 5. Supervise lawsuits brought in the name of the United States, including but not limited to 1A. Civil antitrust enforcement, 2B. Civil rights litigation, 3C. Consumer protection litigation, 4D. Civil fraud cases, 5E. Immigration-related civil litigation. 6. Coordinate with United States attorneys in the conduct of civil litigation. 7. Develop and implement civil litigation policies and strategies. 8. Provide guidance and support to federal agencies on civil legal matters. 10. Perform such other duties as the Attorney General may prescribe. B. Civil Division. The Civil Division shall be responsible for all matters assigned to the Assistant Attorney Generals for the Civil Division and shall operate under Assistant Attorney General's direction and supervision. 5. Inserting after Section 506B the following new section. A. Paragraph 50C, Public and Legislative Affairs. 1A. Appointment of the Assistant Attorney Generals appointed under Section 506. One shall serve upon the designation of the Attorney General as Assistant Attorney General for Public and Legislative Affairs. 2B. Duties. The Assistant Attorney General for Public and Legislative Affairs shall 1. Head the Public and Legislative Affairs Division of the Department of Justice. 2. Serve as the primary liaison between the Department of Justice and Congress. 3. Represent when summoned the Department before Congress and its various committees. 4. Manage all interactions regarding cases and investigations, policy, legislation, political appointments, and nominations, and other matters in a manner consistent with the Department's law enforcement litigation and national security responsibilities. 5. Develop strategies to execute the Attorney General's legislative initiatives. 6. Respond to inquiries from Congress and notify Congress about Department incentives, policies, and programs. 7. Keep the Department's senior leaders informed about the activities of Congress. 8. Oversee the preparation and coordination of the Department's testimony before congressional committees. 9-10. Advise the Attorney General, Deputy Attorney General, and other department officials on legislative and congressional matters. 10-11. Perform such other duties as the Attorney General may prescribe. 3C. Public and Legislative Affairs Division. The Public and Legislative Affairs Division shall be responsible for all matters assigned to the Assistant Attorney General for Public and Legislative Affairs and shall operate under the Assistant Attorney General's direction and supervision. The division shall include 1. The Office of Legislative Affairs, 2. The Office of Public Affairs, 3. Any other office or unit as determined by the Attorney General. 6. Inserting after Section 506C the following new section. A. Paragraph 506D, Public Defender. 1A. Appointment of the Assistant Attorney General appointed under Section 506. One shall serve upon the designation of the Attorney General as a public defender. The public defender shall have the rank of Assistant Attorney General, but shall remain operationally separate from other Department of Justice functions, under the direct oversight of the Deputy Attorney General. 2B. Duties. The public defender shall have an office that shall 1. Provide legal representation to all individuals charged by indictment or information with violation of the United States Code or the District of Columbia Code, ensuring that such representation is provided in accordance with the Sixth Amendment to the Constitution of the United States, applicable federal laws, rules, and regulations, including but not limited to the Criminal Justice Act and any subsequent laws or guidelines governing the right to counsel for indigent defendants. This representation shall include but not be limited to A. Pretrial, trial, sentencing, post-conviction, and appellate representation. B. Representation in any collateral matters or proceedings arising from the criminal case, including habeas corpus petitions under 28 U.S. Code paragraphs 2241 and 22454. C. Representation during all stages of federal criminal proceedings, including investigations, negotiations for plea agreements, and motions for bail or detention. 2. Retain attorneys at law to zealously advocate for criminal defendants and subjects. 3. Establish and implement standards of professional responsibility and competence in all attorneys and staff providing defense services under the authority of the office. 4. Advise the Attorney General and Deputy Attorney General on matters relating to public defense policy and practices. 2. Section 5C of Title 28 United States Code is amended by 1. In the section heading by striking Assistant Attorney General for Administration and inserting Assistant Attorney General for Policy, Programs, and Administration. 2. By striking subsection A and inserting the following. AA. Appointment. The Attorney General shall appoint an Assistant Attorney General for Policy, Programs, and Administration who shall perform such duties as the Attorney General may prescribe. 3. By striking subsection B and inserting the following. A. B. Responsibilities. The Assistant Attorney General for Policy, Programs, and Administration shall oversee 1. The Justice Management Divisions. 2. The Office of Justice Programs. 3. The Office of Legal Policy. And 4. By redesignating subsection C as subsection D. 5. By inserting after subsection B the following new subsection A. C. Classification. The position of Assistant Attorney General for Policy, Programs, and Administration shall be a career department employee or in the senior executive service. 6. In subsection D as so redesignated by striking administration and inserting policy, programs, and administration. And 7. By adding at the end of the following new subsection AE definitions for the purpose of this section. 1. The Justice Management Division shall serve as the management arm of the Department of Justice, providing administrative support and oversight to ensure efficient and effective operation of the department. 2. The Office of Justice Programs shall provide federal leadership grants, training, technical assistance, and other resources to improve the nation's capacity to prevent and reduce crime, assist victims, and enhance the rule of law. 3. The Office of Legal Policy shall develop and implement the department's significant policy initiative, handle special projects that implicate the interests of multiple department components, and serve as a primary policy advisor to the Attorney General and the Deputy Attorney General. 4. The Office of Legal Counsel shall assist the Attorney General in carrying out the statutory responsibility of furnishing legal advice to the President and heads of the executive departments and provide legal advice to other components of the Department of Justice. 3. Section 507B of Title 28 United States Code is amended by 1. By redesignating paragraph 3 as paragraph 4, and 2. By inserting after paragraph 2 the following new paragraph. A3. Oversee the activities of the intelligence community to ensure compliance with the Constitution, laws, regulations, and executive orders of the United States, including 1A. Reviewing intelligence collection and analysis procedures. 2B. Monitoring intelligence operations for adherence to approved guidelines. 3C. Investigating potential violations of law or policy. 4D. Prosecuting cases involving treason, seditious conspiracy, unauthorized release of classified information, or any cases referred by the intelligence community or the Attorney General. 5E. Reporting to the Attorney General on intelligence activities that raise legal or policy concerns. And 6F. Recommending corrective actions as necessary. And Section 3. Conforming amendments. A. The table of sections for Chapter 31 of Title 28 United States Code is amended by 1. Inserting after the item relating to Section 506 the following new item. 1. 506A. Assistant Attorney General for the Criminal Division. 2. Inserting after the item relating to Section 506A the following new item. 1. 506B. Assistant Attorney General for the Civil Division. 3. Inserting after the item relating to Section 506B the following new item. 1. 506 Assistant Attorney General for Public and Legislative Affairs. 4. Inserting after the item relating to Section 506C the following new item. 1. 506D Public Defender. 5. Inserting after the item relating to Section 506 the following new item. 1. 506A Assistant Attorney General for the Criminal Division. 6. Striking the item relating to Section 507 and inserting the following. 1. 507 Assistant Attorney General for Policy, Programs, and Administration. Hello? Hello, okay, the last thing. Any reference in another federal law, executive order, rule, regulation, or delegation of authority, or any document of or relating to the Assistant Attorney General for administration shall be deemed to refer to the Assistant Attorney General for Policy, Programs, and Administration. That is all. Mr. President of the Senate,
Yep.
it has been read.
This item is referred to the Committee on the Judiciary. The chair will now move to calendar number 10, Senate Resolution 6, Judicial Organization and Administration Act 2024. Pursuant to Rule 1, I appoint Asa Raps to the chair for the reading of calendar number 10, Senate Resolution 6, Judicial Organization and Administration Act 2024.
A bill being enacted by the Senate and House of Representatives of the United States and Congress assembled, Section 1, short titled, "This piece of legislation it shall be referred to as the Judicial Organization and Administration Act of 2024. Section 2, general provisions. Any part of any act, joint resolution, memorandum, or codified law that conflicts with this act shall be deemed null and void. This act shall be reservable, in which, if any provision of this act is found unconstitutional, the rest of this act shall be in full effect unless also found unconstitutional. This act shall go into effect immediately." Title 1, the United States Judicial Conference, Section 101. Conference and Council of Judges and Justices, entire section except for 3 through 4 of 28 U.S. Code Chapter 15 are hereby repealed and considered void. Section A of 28 U.S. Code, Section 331 is hereby added to read as follows: "The Chief Justice of the United States shall summon monthly the Chief Judge of each court, 2 judges of each court, and 2 justices of the Supreme Court to a conference at such time and place in the United States as he may designate. He shall preside at such conference, which shall be known as the Judicial Conference of the United States. Such sessions of the conference may be called by the Chief Justice at such times and places as he may designate." Section B of 28 U.S. Code, Section 331 is hereby added to read as follows: "The judge shall be chosen by the concurrence of a majority of all the judges of their court, and when there is no concurrence, then by the Chief Judge of their court, and shall serve as a member of the Judicial Conference of the United States for a term of not less than 4 months successive months, nor more than 6 successive months, as established by a majority of all the judges of their court. The justice shall be chosen by the Chief Judge and shall serve as a member of the Judicial Conference of the United States for a term of not less than 4 successive months, nor more than 6 successive months, as established by the Chief Judge. The Magistrate Judge cannot serve as a member of the Judicial Conference." Section C of 28 U.S. Code, Section 331 is hereby added to read as follows: "If the Chief Judge, the judge chosen by the judge of their court, or the justice chosen by the Chief Justice is unable to attend, the Chief Justice may summon any other judge and/or justice, as the case may be. Every judge and justice summoned shall attend, and unless excused by the Chief Judge, shall remain throughout the session of the conference and advise as to the needs of his court, and to any matters in respect of which the administration of justice in the courts of the United States may be improved." Section D of 28 U.S. Code, Section 331 is hereby added to read as follows: "The conference shall make a comprehensive survey of the condition of business in the courts of the United States and prepare plans for assignment of judges to or from circuits or districts where necessary. It shall also submit suggestions and recommendations to the various courts to promote uniformity of management and procedures and expeditious conduct of court business. Conference provided in Chapter 16 of Title 28 as a conference or through a standing committee. If the conference elects to establish a standing committee, it shall be appointed by the Chief Justice, and all petitions for review shall be reviewed by that committee. The conference or the standing committee may hold hearings, take sworn testimony, issue subpoenas and subpoenas duces tecum, and make necessary and appropriate orders in the exercise of its duties. Subpoenas and subpoenas duces tecum shall be issued by the clerk of the Supreme Court at the direction of the Chief Justice or his designee, and under the seal of the court. The conference may also prescribe and modify rules of the exercise of the authority provided in Chapter 16 of Title 28. All judicial officers and employees of the United States shall promptly carry into effect all orders of the Judicial Conference or the Standing Committee established pursuant to the section. Section E of 28 U.S. Code, Section 331 is hereby added to read as follows: "The conference shall also carry on a continuous study of the operation and effects of the general rules of practice and procedures now or hereafter in use to as prescribed by the Supreme Court for the other courts of the United States prior to law. Such changes and additions to those rules as the conference may deem desirable to promote simplicity, procedural fairness, and administration, the just termination of litigation, and the elimination of unjustifiable expense and delay shall be recommended by the conference from time to time to the Supreme Court for its consideration and adoption, modification, or rejection in accordance with law." Title 2, United States Federal District Court, Section 201, Generality. United States Federal District Court, known as United States District Court shall consist of 8 district judges nominated by the president with the advice and consent of the Senate, while the judges shall be nominated as the chief judges of the district court by the president with the advice and consent of the Senate. The United States District Court shall have original jurisdiction in all civil and criminal cases. Section 202, Precedence of District Judges. The entire section of 28 U.S. Code, Chapter 5, Section 136 is hereby repealed and considered void. Section A of 28 U.S. Code, Section 136 is hereby added to read as follows. In cases where the position of Chief Judge for the District Court is vacated, the most senior judge serving in the capacity of Chief Judge will take on this role until a new Chief Judge is nominated under the first sentence of subsection A of Section 201. If the Chief Judge desired to be relieved of their duties as Chief Judge while retaining active status as District Judge, they may so certify to the Chief Judge of the United States. Thereafter, the Chief Judge of the District shall be the most senior District Judge until a new Chief Judge is nominated under the first sentence of subsection A of Section 101. Section 103, Duties and Powers of the Chief Judge of the District Court. The Chief Judge of the District Court shall have the authority to issue directive orders to the District Court's administrative personnel and staff to improve the efficiency and effectiveness of court operations. The directive orders issued by the Chief Judge shall be aimed at streamlining processes, reducing backlog, and ensuring compliance with applicable laws and regulations, and promoting fair and impartial administration of justice. The Chief Judge shall work in consultation with the judges of the District Court, relevant court personnel, and stakeholders to identify areas of improvement and implement necessary changes through the issuance of directive orders. The judges of the District Court and administrative personnel shall comply with directive orders issued by the Chief Judge, subject to any legal limitations. The Chief Judge shall monitor the implementation of the directive orders and report progress to the Judicial Conference. The Chief Judge's duties and powers may be extended at the discretion of the Supreme Court. In the absence of a court clerk, the Chief Judge shall assume the duties of the clerk of the court until the appointment of a new court clerk by the Chief Judge. Duties and powers of the Chief Justice of the United States. The Chief Justice of the United States shall ensure the expeditious handling of the affairs of the various federal courts in consideration of the fundamental rights as well as both statutory and common law safeguards and limitations, thereby preventing undue accumulation or procrastination of both civil and criminal cases. In pursuance of these responsibilities and other associated obligations, Chief Justice is duly authorized and empowered to secure adequate legal representation for any individual accused of an offense within the United States courts by suggesting modifications to the public defender system to the Attorney General. 2. To undertake affirmative and suitable measures to rectify or alleviate any unfavorable circumstance or condition impeding the proper functioning of the judicial system, and to adopt any additional measures as may be indispensable for the systematic dispensation of justice, irrespective of whether such measures are explicitly delineated in this section or elsewhere. The Chief Justice is further empowered to issue directive orders to ensure the orderly administration of justice. Whenever the Chief Justice takes action pursuant to his obligations outlined in Section 203B of this title, including the issuance of the directive orders, he shall furnish a report to the Senate and House committees and the Judiciary and the Judicial Conference, providing a comprehensive account of 1. The specific actions undertaken, including any directive orders issued, 2. The rationale underpinning the adoption of said action, and 3. The alignment of the actions with his responsibilities outlined in Section 203B of this title. Section 205, Appointment and Tenure of the United States Magistrate Judges. The entire sections of 28 U.S. Code Chapter 43 are hereby repealed and considered void. The Section A of 28 U.S. Code Section 631 is hereby added to read as follows. Judges of the District Court shall appoint United States Magistrate Judges. The appointment, whether an original appointment or reappointment, shall be by the concurrence of a majority of all the judges, and when there is no such concurrence, then by the Chief Judge. Where the conference deems it desirable, a magistrate judge may be designated to serve in the district for which they are appointed. Such a designation shall be made by the concurrence of a majority of the judges and shall specify the duties to be performed by the magistrate judges in the district. Section B of 28 U.S. Code Section 631 is hereby added to read as follows. No individual may be appointed or reappointed to serve as a magistrate judge under this title unless 1. They have served 90 days in the federal bar, except if the federal bar has been disbanded, in which case this provision shall not apply until the federal bar is reinstated. 2. They are determined by the district court to be competent to perform the duties of a magistrate judge. 3. They are selected pursuant to the standards and procedures promulgated by the Judicial Conference of the United States. Such standards and procedures shall contain provisions for public notice of all vacancies in the magistrate judge positions and for the establishment by the district court of merit selection panels composed of residents of the individual judicial district to assist the court in identifying and recommending persons who are best qualified to fill such positions. Section 206, jurisdiction powers and temporary assignment of United States magistrate judges. A, the Section A of 28 U.S. Code Section 636 is hereby added to read as follows. The magistrate judge may, upon the request of a judge of the district court or a visiting justice of the Supreme Court, or by procedural mandate, 1. Hear arraignment and pretrial motions, 2. Impanel a jury, 3. Issue summons, warrants, and other writs, 4. Preside over a bench trial in the absence of a judge or justice, provided that 1. Such trial must be recorded, and 2. The final judgment is rendered by the presiding judge or justice. Section 207, abolishing assignment of retired justices or judges to active duty. The entire sections of 28 U.S. Code, Chapter 13 are hereby repealed and considered void. B, as outlined by the group management, any justice or justice who has concluded their regular active service through retirement is ineligible to carry out judicial responsibilities. The group management ensures adherence to the rule that no former judge or justice in retirement is allowed to resume their duties. Title 3, statute of limitations. Any crime under Title 18 of the United States shall generally have a statute of limitations of 75 days, provided that the offense is punishable by imprisonment or deprivation of liberty. Notwithstanding this provision, the following specific offenses shall be subject to a statute of limitations of 110 days. Title 18, Chapter 29 of the United States Code, Title 18, Chapter 37 of the United States Code, Title 18, Chapter 47 of the United States Code, Title 18, Chapter 111A of the United States Code, Title 18, Chapter 1113 of the United States Code, Title 18, Chapter 1115 of the United States Code, Title 18, Chapter 118 of the United States Code, Title 18, Chapter 1111 of the United States Code. Section 302, statute of limitations for civil cases. Any civil case shall generally have a statute of limitations of 60 days from the time when the cause of action accrues. Section 303, general limitation and oversight. A, in addition to the specific limitations established in Section 301 of this title, a general statute of limitations of 75 days shall apply to all criminal offenses punishable by imprisonment or deprivation of liberty under the United States Code. B, in addition to the specific limitations established in Section 302 of this title, a general statute of limitations of 30 days shall apply to all civil cases arising under federal law, ensuring that parties have a reasonable opportunity to seek redress for their grievances. C, Congress shall monitor the implementation of this act to ensure that civil justice is efficiently administered without unreasonable delay. Mr. Vice President.
Thank you, Senate Majority Leader Acid Reps. Pursuant to Rule 1, I appoint Batman Yusuf II to the chair for the reading of calendar number 11, Senate Resolution 46, to ensure the independence of the executive branch of our judicial system.
Can you hear me?
Yes,
Hello? Oh, okay.
we can hear you.
A bill to ensure the independence of executive branch and fair judicial system. Be it enacted by the Senate and House of Representatives of the United States Congress assembled. Section 1. Repeal of H.R. 76. Section 6 of H.R. 70 is repealed. Section 2. Partial repeal of Pub L. 96-3. A. Section 202 of Public Law 96-3 Speedy Trial Act of 2024 is repealed. B. Section 203 A.2 of Public Law 96-3 Speedy Trial Act of 2024 is repealed. C. Section 204 B of Public Law 96-3 Speedy Trial Act of 2024 is amended to say a trial must take place within 14 days upon a summons from the court first instance. D. Section 204B1 of Public Law 96-3 Speedy Trial Act of 2024 is amended to say the court of first instance may deem these rights have been waived by omission if the defense acts in a something word unnecessarily vexatious or bad faith manner in order to delay passes the 14-day mark. E. Section 204D is added to Public Law 96-3 Speedy Trial Act of 2024 and reads, a judge may not receive or request a second response from a party responding to a motion. Section 3 Amendments to Pub L 93-1. A. Section 5C is struck and amended to say the informed report shall be no less than 1 page and no more than 2 pages, with images and data tables excluded. B. Section 6B is struck and amended to say every person who having been required to report to their activities to the Congress under this act willfully makes default or having submitted fails to satisfy the required criteria under this act shall be deemed guilty of a misdemeanor punishable by a fine of not more than 75,000 DC cash nor less than 5,000 in imprisonment in a common jail for not less than 5 nor more than 12 days. I'm done.
Thank you, Senator Youssef. The item Judicial Organization and Administration Act of 2024 is referred to the Committee on the Judiciary. The item to ensure the independence of the executive branch and fair judicial system is referred to the Committee on the Judiciary. The chair will now move to calendar number 12, Senate Resolution 19, to repeal Senate Resolution 14. Senate Resolution 19. Resolved, Senate Resolution 14 is repealed. This item is referred to the Committee on Rules and Administration. The chair will now move to calendar number 13, Senate Resolution 19, to restrict members of Congress from taking upon other responsibilities that would interfere with their sworn congressional offices and duties discharged. A concurrent resolution to restrict members of Congress from taking upon other responsibilities that would interfere with their sworn congressional offices and duties discharged. Section 1. It is improper for any member of Congress to hold a role in any federal agency or department. It is improper for any member of Congress to be an active member of the United States military. Section 2. Upon electoral results, newly elected members of Congress shall resign from all responsibilities and positions defined in Section 1 defined responsibilities. No newly elected member of Congress shall take an oath of office for their elected office until Section 2, Course of Action for Violations, newly elected member Clause A is completed. Section 3. If a sworn member of Congress takes on new responsibilities that violate Section 1 defined responsibilities, it is reasons and grounds for expulsion which must occur following chamber rules. Section 4. This resolution shall go into effect immediately upon passage. It is of the due diligence of the administrative office of each chamber to ensure that no member of their chamber is in violation of this resolution. This item is referred to the Committee on Rules and Administration. Does anyone second Snowbleed's motion to go into executive business?
Bye, ladies. Oh, can we vote?
Okay, it has been 1 minute. On this vote, the ayes are 6, the nays are 0. The Senate will now proceed to executive business. We shall proceed to readings of nominees before the Senate.
Wait, hello?
Yes, hello, Senator Takis.
Someone? Did I miss something?
No, we are moving to executive business.
Oh. Okay.
Pursuant to Rule 1, I appoint Snowbleed to the chair for the reading of executive business.
Oh my god.
Calendar number 14, Gentleman Jalix to be the Secretary of State. Referred to the Committee on the Judiciary. Calendar number 15, JJC 0308 to be Ambassador of the United Nations, referred to the Committee of the Judiciary. Calendar number 16, Ghostful to be Secretary of Homeland Security, is referred to the Committee on Homeland Security. Calendar number 17, Warlockings to be Deputy Secretary of Homeland Security, is referred to the Committee on Homeland Security. Calendar number 18, Technical Law to be Commander of the Coast Guard, is referred to the Committee on Homeland Security. Calendar number 19, EOD Twilight to be Vice Commander of the Coast Guard, is referred to the Committee on Homeland Security. Calendar number 20, Revellium to be Deputy Director of the Defense Intelligence Agency, is referred to the Committee on Homeland Security. Calendar number 21, Winterday to be Secretary of Transportation, is referred to the Committee on the Judiciary. Calendar number 22, Todd Manick to be Inspector General of the Department of Transportation, is referred to the Committee on the Judiciary. Calendar number 23, J.T. Port to be Federal Judge in the United States District Court, is referred to the Committee on the Judiciary. Calendar number 24, Grant Pagobis to be Administrator of the National Employment and Labor Authority, is referred to the Committee on the Judiciary. Calendar number 24, S. Reps to be Attorney General, is referred to the Committee on the Judiciary. Calendar number 26, Chris Full to be Deputy Attorney General, is referred to the Committee on the Judiciary. Calendar number 27, Sir Reggie to be Director of the Federal Bureau of Investigation, is referred to the Committee on Judiciary. Calendar number 28, Jackson R. Braddock to be Deputy Director of the Federal Bureau of Investigation, is referred to the Committee on Judiciary. Calendar number 29, Echoback to be Director of the United States Marshal Service, is referred to the Committee on the Judiciary. Calendar number 30, Vet Excellus to be the Deputy Director of the United States Marshal Service, is referred to the Committee on the Judiciary. Calendar number 31, Space Lawyers to be Secretary of the Treasury, is referred to the Committee on the Judiciary. Calendar number 32, Captana Nico to be Deputy Secretary of Commerce and Labor, is referred to the Committee on the Judiciary. Calendar number 33, Harrods to be Director of Special Forces, is referred to the Committee on Homeland Security. Calendar number 34, Mehmet Siri to be the Deputy Director of the Special Forces, is referred to the Committee on Homeland Security. Calendar number 35, Devexter to be Deputy Secretary of Defense, is referred to the Committee on Homeland Security. Calendar number 36, Mid Foley to be the Director of the Defense Force Protection Agency, is referred to the Committee on the Homeland Security. Calendar number 37, Sage Soup to be Deputy Director of the Defense Force Protection Agency, is referred to the Committee on Homeland Security. Calendar number 38, Magnus Titanate to be Deputy Director of National Intelligence, is referred to the Committee on Homeland Security. Calendar number 39, Unnote to be Commander of SWAT, is referred to the Committee on the Judiciary. Calendar number 40, Honey Soup to be Deputy Commander of SWAT, is referred to the Committee on the Judiciary. Thank you, President of the Senate.
Thank you, President Pro Tempore Snowbleed. Okay, is there any further business to come before the Senate? Motion to adjourn has been recognized.
Are we done?
Voting.
We're doing another session after this, by the way, so don't leave.
Oh my god, this is gonna be so fun.
The next session is gonna actually have voting.
Are we doing a session at 8:30 or 8 or we?
Wait,
Now.
only the thing that got discharged. Right, I said
What?
only everything that got discharged from the committees.
Yeah.
Okay, that's fine.
Isn't there like a medal or a award ceremony
is Raz
at,
Van
like,
Down there?
now? Isn't there an event right now? Like an award ceremony?
We
Yeah,
gotta
you
do our
should go,
duties,
actually,
Hellenic.
Helen. You should go to the ceremony.
No.
Only Helen.
Ceremony
I
is
think you
in 25,
invited. You
in
wanted there.
25 minutes. In 25 minutes. It's not now.
Can I send someone? Can I like send like an Uber Eats driver to pick it up for me?
Surely it's been a minute at this point.
Yep, it has.
Surely.
On this vote, the A's are 7, the Nays are 2. The Senate is adjourned.
All right, everyone sit back
Go.
down. Get back in your seats. Everyone get back in your seats.
Oh.
All right, I gotta go pee. So, pursuant to Rule 1, I appoint someone
Whoa!
as chair.
Decorum, sir. Please, don't talk about your penis.
Decorum,
Hey,
please.
who's talking about their penis?
Hey,
Wrath.
order,
Wrath, come on,
please.
bro. We do that in private.
Backus, are you going to that ceremony or are you running?
I think
it?
you should
Are
go,
you
actually,
running?
Helen. I think they.
All right. This is Jay Tracer, legislative correspondent for the American Times. That is the end of the first Senate session. We will likely not be broadcasting the second Senate session, sadly. As for the debrief on what just happened, we have we will go over quickly the laws that were passed. So we have motion to vote on the motion to vote to move to legislative business. We got that done. So we have all the nominations complete. That's going to get over to the committee. No bills were passed this entire time, and so that's lots of talking, just a lot of bill reading. One of the longest legislative sessions I've seen personally. And that's pretty much it. Thank you, everybody, for tuning in. This has been the American Times. Thank you.